daughter, who was then in the first grade, invited me to show and tell. I arrived there that day about 10 o'clock, and she took me by the hand and led me to the front of the class, and she said, "This is my father, Mr. D. Michael Kreitz. He works for President Reagan. He's a federal prostituter." So. Maybe there's something to be said about that today. I want you to know how very much I really appreciate the Buckeye Institute inviting me to be a participant on this panel. I have to tell you that Mr. Fischer, I could not put the book down. John, you did a tremendous job. As one who's been a prosecutor for 22 years, I was a United States Attorney, Assistant United States Attorney, Organized Crime Prosecutor. I was the first Assistant County Prosecutor, Assistant County Prosecutor, City Prosecutor. So I kind of prosecuted all levels of government. I've got to tell you what, I think that book should be mandatory reading for anybody that's a prosecutor. It just chills run up and down my spine when I read that, and I didn't go through anything that you did, Mr. Fischer, and you know, God bless you for what you went through, and let's hope that as a result of that, maybe there's going to be some positive changes in the system. But, let me talk to you a little bit about what my concerns are as I read this book, because the very first thing that just grabbed me when I read it was that, and I mentioned it to John this morning, was that there was next to no mention of the United States Attorney himself. It was all about the Assistant U.S. Attorney did this, the Assistant U.S. Attorney did that. And that's the first thing that really grabbed me, because it's so important in our federal system that the men and the women that are selected to serve as the United States Attorneys by the President and confirmed by the Senate are people of courage. People that have the courage to go ahead and follow the evidence where it takes them, and the courage to make the right decision when the evidence does not necessarily result in what would be an indictment or a charge. It's very, very difficult sometimes when you're under the political gun and you're in the political limelight, as most United States attorneys are today, because there's been a great expectation that when you become U.S. Attorney, that the next step is going to be you're going to be a U.S. District Court judge, or you're going to run for Attorney General, you're going to run for a governor, you're going to run for president, whatever it is. There's a lot of pressure on those people, and as a result of that, they sometimes feel that they have to go ahead and make decisions to indict, and other decisions that are on the cusp. They're marginal. And I'm not saying they're bad people. I'm just saying, like other human beings, they have a tendency to go ahead and succumb on occasion. And I think it's very important that the screening process that's employed in the selection of United States attorneys be one where they very seriously vet the candidates. And I'm not sure that that is always the case. And I'm not making reference to any one individual here in Ohio or Kentucky or any other place. But I can tell you that it always was better back when I did it, okay? But I can tell you when I went through the process to become the United States Attorney, it was not an easy process. There were like 40 or 50 interviews here in the state, and then I went to Washington, the Department of Justice. I screened with the Attorney General of the United States, who was Ed Meese at that time, and then a fellow by the name of Steve Trott, who was the Associate Attorney General that's now in the Ninth Circuit Court of Appeals out in San Francisco. And then, after I had been vetted there and the other two people had been vetted, I ended up going over to the White House and meeting with the people there, and I was vetted there as well before the decision was made to nominate. Now, I'm not saying that that's the perfect system, but I'm telling you that it's absolutely important that we have U.S. attorneys that have been vetted, that we know will make good decisions in arduous situations. And I'm not sure that that came through in what I read in that book. And again, I'm not here to pass judgment. I read the book. I'm telling you what my read was on it. But it's absolutely essential that you have that kind of strong leadership. And there's a tendency sometimes for young U.S. attorneys, and I'm talking young in terms of age or young in terms of experience, to go ahead and give in to the pressure of the agency. It's easy to say that, well, the agency, in this case it was ICE, it could be the FBI, it could be the IRS, doesn't matter, it could be the DEA, they're my client. And David, you and I talked about that a little bit. It's easy to say, well, then I'm going to follow the lead that's been set down by the agency. The agency wants to go ahead, they want a search warrant, and they want to go ahead and execute that search warrant, and they want these 4 people to be charged, and they're my client, I'm going to go ahead and do it. Whoa, wait a minute. To a certain extent, they are your client, but on the other hand, you're the United States Attorney, or you're the Assistant United States Attorney, and you've been charged under your oath of office to go ahead and to do justice. To do justice doesn't mean that you necessarily count the marks on your gun belt, where you've gotten all those convictions. How many times do you hear a prosecutor walk around and they'll strut around, and particularly younger ones, and they'll say, I've never lost a case. You know, easy, because he's probably never tried a case. He's probably plea bargained every case, okay? Or he's never tried a difficult case. That's not what this is all about. You need somebody that's in charge. And my sense is that the United States Attorney was not engaged for whatever reason in this process, and that's something that you cannot have. Because I got to tell you that the influence of United States attorneys has grown tremendously in the 30 years that I've been practicing law. They always have been well regarded, they've always had influence, but with the expansion of federal law in the criminal arena over the last 20 years, the amount of power and influence that they have over our day-to-day lives is incredible. I say that as having been one. I mean, I was 36, 37 years old when I was the United States Attorney in the Southern District of Ohio. I think I was the youngest one in the country, or certainly one of the youngest ones. And you know, what I had was about 6 years prosecution experience. I'd been a naval officer, Vietnam veteran, that kind of thing. I suppose that helped. But I was young, and it was easy to be led by the agents. Fortunately, I had a really strong staff around me that got me through the first year and kind of showed me the ropes. So what am I saying here? First point is, we must have a system where the president is nominating absolutely the finest men and finest women to be United States Attorney. Men and women of courage, of leadership, and of character. Secondly, you know, the first thing that when I read it, I was talking to one of the people in my office, and I said, you know what? You know, I think the internal controls in the office really broke down. And one of my colleagues says, I think the grand jury system broke down. Well, I don't think the grand jury system necessarily broke down, but a grand jury is not a rubber stamp for the United States Attorney. It's not a rubber stamp for an assistant United States Attorney. The grand jury has to be used in such a way that it is just that. It's a screening body to determine whether or not there's probable cause to believe that a crime has been committed. Now, apparently, in this case, they were able to convince the grand jury, at least with respect to 6 individuals, that they should be indicted, okay? But what I find is really interesting, I don't know, never will know whether or not they presented evidence on the construction company itself, but isn't it interesting? It seems to me that if they had evidence at that point in time against the company, they probably would have went ahead and introduced it and probably sought an indictment, but they didn't. It suggests to me, and I have no more evidence in the case than you folks did, that this person probably didn't have sufficient evidence to go forward on the company. What really disturbs me is then we go ahead and we charge these 4 or 6, initially it was 4, then it became 6, I guess, with the indictment. And then what we do, since we don't have enough evidence, it appears that then they try to extort a plea agreement out of the company in exchange for the dismissal of the 6 people that now have been indicted. You know, if that's in fact what really happened, I find that reprehensible. Why? Because, you know, we prosecutors, and I want you to know, I have never loved a job professionally more than I did as being the United States Attorney and an assistant United States Attorney. I love being a prosecutor, I still do. And I serve as special counsel around the state on it. But I have to tell you what, you know, if that's what this case was all about, then the system broke down. Because quite frankly, if they had the evidence against the company, they would have presented to a grand jury. It's very clear to me that what they were trying to do was extort a plea out of the company. What bothers me about that is I'm not sure, based on my reading of the book, whether or not there was any evidence at all. Clearly, you know, I walk away feeling there was no evidence at all to believe that the company should even be considered for indictment. And how the dickens it got to the point where they go ahead and charge 4 people initially, indict 6, and then they try to roll those people into an indictment, a charge, a felony count against the construction company and extort $1 million, I find that to be very reprehensible. That's not what the system's all about. If there was evidence that the company was engaged in criminal activity, then a prosecutor speaks through his indictment or he doesn't speak at all. In this particular case, they went ahead and they blinked. And as a result, the case was dismissed. So I think that the grand jury probably traditionally tends to be used more as a board just to seek an indictment as opposed to a screening body to determine whether or not there's probable cause to believe a crime has been committed. Another thing, internal controls in the office. What happened when the AUSA met with the agent? Generally what happens in the office is that the AUSA decides that there's sufficient evidence to believe that we at least ought to proceed with an investigation. Then the next check, as I indicated, is the grand jury. But before it goes to the legislation that is trying to be